Let's say you're an author and you created a book. Now, to protect your economic interest in this book, you must ensure that no one shall create copies of your book, no one shall distribute your book without your permission, and finally, no one shall be able to narrate or convey the story of this book, either in movies, songs, play, or any other way. In short, what you need is you need to regulate the content of this book and decide when and who can have access to the content you have created. Now, this can happen in two possible ways. One, there is understanding among society, and two, there is some sort of protection given by the government. Now, let's just ignore the first part and focus on the second part. This protection, which is provided by the state, is called copyright. Copyright can be understood as set of rights that author receives in his or her creation. Section 14 of Indian Copyright Act defines copyright as exclusive rights to do or authorized to do certain acts. Now, before we cover these acts that are exclusive to the author, let's see what are these creation. Under copyright law, these creations are referred as work, which is defined in Section 2, Clause Y. This section lists down 6 types of work that are A. Literary work, B. Dramatic work, C. Musical work, D. Artistic work, E. Cinematographic work, and finally F. Sound recording. Now let's quickly see what these work basically means. A. Literary work. Section 2 Clause O talks about literary work, but this section does not define literary work, rather it lists down the nature of work that are considered as literary work. Section 2 Clause O reads as, literary work includes computer program, tables, and compilation, including computer database. We can understand literary work as any thought, idea, or information expressed in words, symbols, or any other verbal or numerical symbols. So, by this understanding, any book, research paper, novel, essay, article, all are the examples of literary work. B. Dramatic work. A dramatic work in copyright law includes various types of creative performance and arrangements. Especially it encompasses any piece of recitation, example poem or spoken word performances. B. Choreographic work, example dance routine. Entertainment in dumb show, example mime performance. Or scenic arrangement or acting form fixed in writing or otherwise. Now it is important to note that dramatic work does not include cinematographic films. The term focuses on performance and arrangement intended for live presentation or fixed in some tangible form but excluded films or video recording. C. Musical work. A work that consists of music, including any graphical notation of that music, example sheet music. However, this definition does not include any words intended to be sung with the music, meaning lyrics, or any action or performance meant to accompany this music. Essentially, a musical work focuses purely on music itself, separate from any lyrics or choreographed action. D. Artistic work. Artistic work consists of A. Painting, sculpture, drawing, an engraving or a photograph. B. A work of architecture. C. Any other form of artistic craftsmanship. Now, one thing we should note here is that these works are considered artistic regardless of their artistic quality. E. Cinematographic films. Section 2F defines cinematographic films as a visual recordings accompanied with sound. Any video that are produced in this manner will fall under the category of cinematographic film. For example, movies, short films, documentary, or any other video with the sound. F. Sound recording. Section 2XX refers to the sound recording and it defined it as sounds that can be reproduced irrespective of medium of recording and method used to produce such sound. For example, audiobook, sound effect, music recordings, etc. Under copyright law, rights can be classified into two broad categories: moral rights and economic rights. Under moral rights, as an author, you have basically three rights in your creation, irrespective of the fact that you have assigned your work either in whole or in part. These rights are: number one, you can claim authorship of your work. Number two, you can restrain any act that damages, mutilate, or distort your work. And number three, you can claim compensation if such mutilation, distortion, or even modification that causes you to lose your honor or reputation. Whereas, under economic right, as an author, you are entitled to do: number one, create copies of your work. Number two, distribute your work. Number three, to perform your work in public. Number four, create adaptation of your work, meaning changing the original format of the work. For example, let's say originally you have written a story. Now, as an author, you can make movies, play, or use any other medium to convey your story. Number five, create translation of your work. Section 14 of Indian Copyright Act defines these rights. It lists down the various rights that author has depending upon the nature of work. This section is divided into 5 clauses that list down the rights depending upon the nature of your creation. If your creation falls in the category of literary, dramatic, or musical work, Section 14 Clause A defines the right you have in your creation. Clause B lists down the additional rights for the literary work that are computer programs. If your creation is an artistic work, you have Section 14 Clause C. For cinematographic films, Section 14 Clause D. And finally, Clause E for sound recordings. Let's quickly see Section 14 Clause A and B as they are relevant for computer programs. As per Section 14 Clause A, the author of a literary, dramatic, or musical work have following rights. Number one, to reproduce your work in any material form, meaning you can create copies of your work. Number two, to issue copies of your work to public, meaning you can distribute your work. Number three, to perform your work in public or communicate it to the public. Number four, to make any cinematographic films or sound recording of your work. Number fifth, to make translation of your work. Number six, to make adaptation of your work. And number seven, to do any of the above in relation to the translation or adaptation you've created out of your work. Whereas Section 14 Clause B provides two additional rights in relation to the computer programs. Number one, you can sell or rent your computer program. And number two, you can offer to sell or offer to rent your computer program. Meaning of copyright as per the Act is to do or authorize someone to do above mentioned actions. Meaning you can create copies of your work, distribute them, create adaptation, create translation, and so on and so forth. You can also authorize someone else to do all of these on your behalf. What this also means is that you can restrict someone from doing any of the above mentioned activities without your prior permission. And as an author, these exclusive rights are granted to you for your lifetime plus 60 years.